Good evening, everybody. I am Kriti Sanghi, and I welcome you all to the Samisti Samvid series webinar to provide an insight on regulations governing the foreign direct investment in India. The panelist for the webinar is Mr. PRASHANT JAIN, co-founder and partner at Samisti Legal. Mr. Prashant has extensively dealt in matters relating to FEMA and various cross-border investments, and he would be sharing deep insights into the FDI based on his practical experience. Prashant sir, you may kindly take over now.
Thanks, Kriti. My screen is visible?
Yes, sir.
Okay, thank you. So the agenda for today's discussion would be to touch upon the basics of foreign direct investment into India and what kind of routes are available for different sectors, including the post facto filing which has to be done for any foreign direct investment which is brought into the company. And once we have understood the basics of the foreign direct investments, then maybe we will get into the certain complicated aspects of foreign direct investment, which could be downstream investments, swap of shares, and certain case studies in terms of how the FDI law has evolved. So that would be the broad agenda of today's discussion. So just to give you a brief overview how FDI law has evolved. So prior to 1991, India had a very restricted foreign direct investment policy. But in 1991, government introduced liberalization, and then they have amended the FDI policy, and the FDI sector, FDI sectorial cap have been basically open for a lot of sectors. So in 1991, government came back with liberalized policy. Pursuant to that, a lot of companies in India were open for foreign direct investment. So that was the era when government thought that India should become a developed company in terms of getting foreign direct investment into India and foreign currency. So that's how the government thought that bringing FDI liberalization would get foreign currency, and then maybe India would be benefited. That's how the gates were open for different sectors in India. So that was the background. So just to give you the administrative framework, how FDI is monitored in India. So Department of Industry, Policy and Promotion generally regulates the FDI policy. They come out with the policy every year in terms of which business should be allowed, how much foreign direct investment, and then RBI monitors the administrative and compliance aspects of FDI. So these are the two regulators, Ministry of Commerce with its wing DIPP, and then RBI monitors the compliance and administrative aspects of FDI. So that is the regulatory scenario in terms of FDI into India. So just to give you a brief, there are two kinds of entry routes in India. One is automatic route, the other one is government route. So when I say automatic route, basically it is derived from the business which the company is doing. So automatic route means that to get the FDI, foreign direct investment, without government approval, then that business can get the FDI under automatic route. Government route, again, there are certain businesses where government wants to basically review the business and review the foreign investor who is coming into the business, and basis that you have to file an application with the DEA, and then the DEA will review. DEA, when I say DEA, it is the wing of DIPP. So they will review your application, and then if they are satisfied that okay, they can allow you to get the FDI into your business, then they will approve it. So it is an approval route wherein government approval has to be taken for certain businesses. So we will discuss what are the businesses where government approval will be required, and what are the businesses where automatic route FDI is allowed. So these are the two routes, automatic route and government route. For automatic route, without government intervention, you get FDI into the company and do what kind of whatever filings are required under the RBI regulations. Under government route, you file an application with the Department of Industrial Policy and Promotion, which is DIPP, and their wing DEA. And once they have blessed the application, once they have given the approval, then you can get the FDI. So these are the two basic routes. Now, as I said, these are some illustrative list of businesses where FDI can be brought under automatic route. Just to give you a few sectors, maybe information technology, telecom, insurance. Insurance again only is capped to 49%. So again, under automatic route, you could have businesses where 100% FDI is allowed in that business, or there could be a sectorial cap. So when I say sectorial cap, it could be 24, 26, 49, 74, 76, but not 100. So government may allow certain businesses which can get 100% FDI, which means that 100% the business can be 100% owned by person resident outside India, or they have given sectoral caps for certain sectors. As insurance, it only allows 49%. Telecom, 100% is allowed. IT, 100% is allowed. In financial business, 100% is allowed. Real estate, so when I say real estate, again, real estate has a definition, what is a real estate business. So generally, the definition which has been given by the government here is any company which wants to basically do any kind of business which is not purchase of land but relates to a real estate business. So purchasing and selling of land, business related to purchasing and selling of land is completely prohibited. Other than that, if any business of creating infrastructure to the what do you call the other parts like malls and all, those kind of real estates can be done, but not pure purchase and sale of land. So real estate again has a specific definition. So if you are falling under that definition, then you can get the FDI under automatic route 100%. Infrastructure, manufacturing, hotel and tourism. is allowed. So under this route, if this kind of businesses want to get FDI, then they have to file an application with the regulator. Once the regulator blesses it, then they can get the FDI. So these are the two routes under which FDI can be brought into an Indian company. Then there is a negative list wherein these kind of businesses are not allowed to get any FDI. Agriculture, atomic energy, lottery, betting and gambling, chit fund. So this is again an indicative list. So this kind of businesses, FDI is completely prohibited. So for automatic route, you get automatically the FDI, just do the compliances with the Reserve Bank of India. Post you get the FDI. Government route, you file an application with the regulator, take their approval and then get the FDI, and again do whatever filings you need to do with the RBI. Negative list, you cannot get any FDI into this business. This includes, this is the list which I have given on the screen. So some of these businesses, FDI is completely barred. So these are the basics of an FDI. Now, just to give you the definition of FDI, what is an FDI? Foreign direct investment as defined under the RBI regulations and as given by Department of Industrial Policy and Promotion under the consolidated policy. It means any investment which has been put into an Indian company. Again, Indian company could include your private limited company, public limited company, or LLP, limited liability partnership, because limited liability partnerships are also eligible to get FDI. But again, there are different conditions which are attached to it, which we will discuss going forward. So any investment which is put into an Indian company, again / LLP, by a person resident outside India could qualify as an FDI. Again, there are certain riders. This is the basic layman definition, but there could be certain what do you call different aspects attached to it. But in a plain vanilla sense, it's an investment which is invested by a person resident outside India. So that is an FDI. Now, again, one is under which route you have to get the FDI, whether your business is under automatic route, approval route, or negative list. So once you have determined that okay, your business is eligible to get FDI into India, then what is an FDI? So as I said, any investment by person resident outside India into a capital instrument. So again, a person resident outside India can invest in a capital instrument, or they can lend certain money to the company. So if they are lending certain money to the company, that will not come under the FDI regulations. It will go under the external commercial borrowings. It's a pure lending wherein the money has to be repaid back to the investor along with certain interest. So that is a loan which has been given by a person resident outside India to an Indian company. So in that case, that will fall under the ECB regulations. But if it's a subscription towards a capital instrument. So again, what is a capital instrument? Capital instrument means any equity share, compulsory convertible preference share, compulsory convertible debenture, and share warrant. So equity share, it is day one you give them the equity shares, but there could be certain instruments which will get converted into equity shares, compulsory convertible preference shares, or any other instrument which will get converted compulsorily into equity at a later date of point, or at a later date. So those kind of instruments will qualify under the capital instrument. So it has to mandatorily get converted into equity. Then only it will qualify under the capital instrument. If there are any optionalities attached to any kind of a capital instrument like optionally convertible debenture, optionally convertible preference shares, or any other instrument which is optionally convertible, then it will not come under the capital instrument definition. It will go under the ECB regulations. So once you have derived that, okay, your business is eligible to get FDI, then you have to see what kind of instruments you want to issue, whether you are issuing equity shares, compulsory convertible preference shares, compulsory convertible debentures, or share warrants. So these are the four instruments which I can emphasize in terms of qualifying under FDI rules. If these are the four instruments which the company proposes to issue, then it will qualify under the FDI norms. Now, for again, there are two more caveats here. One is partly paid up share, then the other one is share warrant. So partly paid up shares can also be issued, but there are certain conditions which have been attached. Minimum 25% has to be paid upfront, and the balance has to come within 12 months. So if a company wants to issue partly paid up shares to a person resident outside India under the FDI rule, then this condition has to be fulfilled. Then there could be a scenario where the company would want to issue a share warrant. Share warrant is an instrument wherein a part of the consideration is given by the individual or entity to the Indian company or the company which is issuing the share warrant, and then balance will be called at a later date. And if the balance is not brought in by the holder, then the instrument is forfeited by the company. So it's like a right wherein you give a part payment, and then later on, whenever the company calls for it, you have to honor it. If you don't honor, then that instrument falls away. So that is called a share warrant. For share warrant also, there is a similar condition wherein 25% of the consideration has to be paid upfront, and then balance has to be brought within 18 months. So under FEMA, these are the instruments. If it's a fully paid up instrument, then it can be an equity, CCPS, compulsory convertible debenture, and share warrant. And if you want to do a partly paid up, then you can do it subject to these conditions. Now, the other question which can arise here is if the instrument is not compulsory convertible, then as I previously said, if it's not compulsory convertible, then it will go under the ECB regulation. So some of the instruments which can qualify as the ECB has been listed on the screen: non-convertible preference shares, non-convertible debentures, partially convertible preference shares. These all will be treated as ECB. For ECB, you have different regulations, and those have to be followed. Now, once you have basically understood that my company can get an FDI, and then you have taken the FDI, you have complied with the RBI regulations, you have done all kind of filings which have to be done by a company taking an FDI, like filing your FCGPS and all, and then you have issued shares to the foreign investors. Maybe after 1 year, 2 years, or 4 years, or a later part of time, the investors will want to exit the company. Now, there could be 2-3 scenarios. One, the non-resident investors may transfer his shares to a resident, or a resident investor would want to transfer his shares to a non-resident, vice versa. So, in that case, because there is a non-resident involved, there could be certain compliances which have to be taken care in terms of RBI regulations. So, just to take an example, if a non-resident is transferring shares to a resident, so in this case, what is happening? A non-resident is transferring shares to a resident, so the resident has to do a outward remittance to the non-resident as purchase consideration of purchase of shares, right? So if I am a resident, I am buying shares from a non-resident, so I need to pay consideration to non-resident. So I will go to my authorized dealer, I will hand over him all the papers, basis that the remittance will be done by the banker to the non-resident. So in that case, there are certain reporting which have to be done. So again, whether that will require any approval from RBI, it again depends upon the sector in which the company is operating. If the company is operating in automatic sector, then there is no approval which will be required from RBI or any other regulator. The only thing is you have to do certain paperwork in terms of filing of form FCTRS. Then, because a resident is transferring shares to a non-resident, that time you have to get a fair valuation done, and you have to make sure that the price at which the shares are being transferred are not less than the fair value, because the money is coming into India, and the Indian regulator will always want to get at least the fair value of the shares. And when it is vice versa, wherein non-resident is transferring shares to a resident, then the value should not be more than the fair value. So if I am a non-resident, if I am purchasing shares from a resident, that time I have to pay consideration to the resident. So when I'm paying consideration to the resident, that time I have to basically I pay more than the fair value. But when a resident is paying to a non-resident, then it has to be below the fair value. So the concept here is the money should not go outside India or over the fair value, and the money should not come into India below the fair value. That is the concept. And as I said, there are certain forms which have to be filed, and that can be done. If the business is under automatic route, no approval is required. If business is under approval route, you have to take approval. And if the business is under negative list, then a non-resident cannot participate in terms of new shares of the company or in terms of buying shares from the resident. That is also not allowed. So primarily you have to see that business of the company falls under automatic route or approval route. Basis that decide whether this is eligible in terms of divesting the shares to a non-resident, and then in terms of FEMA, whatever pricing guidelines are applicable, those have to be followed. So that is the basic principle of transfer of securities when it comes to a non-resident. Now, so as you see on the screen, there could be multiple scenarios. Transfer of shares from resident to non-resident, transfer of shares from non-resident to resident. Then there is one more category called non-resident Indians. So I will just spend two minutes on this, wherein who is a non-resident Indian. So just to give you an example now, non-resident is a person who is a person resident outside India. He has nothing to do with India. He is a complete, a foreigner who stays in a different country and doesn't have any origins in India. So that kind of a person is called as a non-resident. It could be an individual or it could be an entity. When it comes to a non-resident Indian, so non-resident in India, Indian is defined under the FEMA, who is a non-resident Indian. Earlier, the definition was very loose. It used to say that if a person who is not born in India, but still he has his ancestors who were in India, then he will qualify as an NRI. But now that definition has been taken out. The new definition is either you have to be a citizen of India. That means what? You are a citizen of India, but you are not staying in India. You are staying somewhere. You are staying in US, UK, but you still hold the citizenship of India. That could be one criteria. The other one is you have to be an OCI. So what is an OCI? OCI is a person who holds Overseas Citizen Card of India. So Overseas Citizen of Card of India under the Indian Citizenship Act is given to the people who have connections into India. There are certain conditions. So if you are a OCI card holder, or if you are a citizen of India, even though you don't stay in India, you will qualify under the definition of NRI or OCI. So if you are an NRI, OCI, and if you want to put in certain money into India, you have different routes. One is you can come under repatriation route. So when I say repatriation route is as good as you are coming as a foreign national and then you are investing in India. So whatever is applicable to the pure non-resident, it will be applicable to you. But you also have an avenue wherein you can come on non-repatriation basis. So when I say non-repatriation basis, that means you are putting money into India from your Indian account or a foreign account, but still you are agreeing to the fact that tomorrow whenever you sell the shares, you will not take this money out of India and you will park this in India and then use it in India. So generally people who have gone outside India may have a saving account in India which is redesignated as an NRO account. And if you want to invest from that account, or you have foreign funds but you want to invest into Indian company, and being an NRI you want to do it on a non-repatriation basis, because to do it on a non-repatriation basis, the paperwork will be less. You need not do any reporting to RBI. It is as good as a domestic investment. Then the NRIs can come under the non-repatriation route. So these are the two routes which can be explored by a non-resident Indian, repatriation or non-repatriation. Under the repatriation route, you have to follow all the paperwork, all the reporting which a non-resident has to do. If you are coming under a non-repatriation route, then you are at par with the domestic investor and you need not do any kind of a reporting. No pricing guidelines apply. But if you are coming through a repatriation route, then the pricing guidelines will also apply. So before you take a call, whether you want, if you are an NRI, you want to do the investment through an NRI repatriation route or non-repatriation route, has to be seen. Then there is a slide on gift of shares from resident to non-resident. If a resident wants to give shares to a non-resident, then there are certain conditions. It should not exceed more than 5% of the paid capital. Then because the non-resident is going to hold the shares, whether it falls under automatic route, approval route of negative or under negative list has to be seen. Then there is a cap of using the value of the shares which are getting transferred should not be more than 25,000 per calendar year. If these three conditions are met, then the gift of share can be done by resident to a non-resident. Now there is one more aspect which has to be understood here. Sometimes what happens is if I'm a resident, I am buying shares from a non-resident, but I don't want to give the 100% of the consideration upfront. I want to structure the deal as if I will pay 75% consideration now and balance 25% or whatever percentage. I'm just taking hypothetical numbers. Say for example 25% after fulfillment of certain conditions, by certain conditions which you will define in the contract. Whether those kind of arrangements can be done. So under FEMA, you can get into a deferred consideration model, which should not be more than 25% of the total consideration. So that is allowed, and then the transaction has to be closed within 18 months. So the deferred consideration model works, but it has to be squared off within 18 months. So if you have put certain conditions on the non-resident in terms of maybe the company shares, the shares of which company you are buying, if the company has to basically perform certain number, certain revenue, certain EBITDA, then maybe you can structure it as if, okay, after 6 months I will see how the company is doing, and if the company reaches this level, I will pay you the balance consideration. If those kind of conditions as a resident you want to put it on the non-resident, then you can do it, but the transaction has to be closed within 18 months. That is the condition. Then again, if you want to put that money into escrow and then appoint an escrow agent who will basically see whether the conditions are met or not at the time of remittance, that can also be done. So escrow mechanism is also allowed. So this has to be squared up within 18 months. So this is called as a deferred consideration model, wherein the transaction will be squared off within a specified period subject to certain conditions, but entire consideration will not be paid, only part consideration will be paid on the day of the first remittance. So that is the deferred consideration model. Now, as I discussed, what is the automatic route, approval route, what are the filings which have to be done by a company when the company is taking FDI, how the transfer happens from resident to non-resident, what happens if the NRI is purchasing shares, whether they can come under repatriation route, non-repatriation route, deferred consideration and all. So this is the basic aspects of an FDI. Now there is a complex aspect of an FDI wherein there is a concept called downstream investment and indirect foreign investment. Now, just to give you an example, now if I am a company which has taken certain investments from a foreign national or a foreign entity or a person resident in India, so I am basically called as a company which is having an FDI. It could be 10%, 20%, 40% in the entire shareholding of the company. But what happens is we also have to see what is the percentage of foreign direct investment into your company, and then see whether the downstream investment regulations apply to your company. So when I say downstream investment, that means if you have taken say 5 crores from a person resident outside India and you have given them 40% of your shareholding. So you have to see whether you are a foreign owned and controlled company or an Indian owned and controlled company. So when I say foreign owned and controlled company, that means there are 3 conditions. If my company has any shareholding from a person resident outside India, which is more than 50%, then I am a foreign owned and controlled company, because on my cap table there are investors who are person resident outside India and holding more than 50%. Second condition is, even though the shareholding is less than 50%, but still you have given them the right to appoint majority of the board of directors. So when I say majority of the board of directors, that means what? For example, they are holding 10% shareholding in the company, but contractually you have executed an agreement with them saying that out of the 5 board members, you will have a right to appoint 3 board members. That means what? They are controlling the board. So if that kind of right is given to the foreign person resident outside India, then again it is a foreign owned and controlled company. The third condition which we have to see is whether any rights are given to the person resident outside India, irrespective of their shareholding, to control the management decisions of the company. So when I say management decisions, there could be certain decisions where you have to go to the person resident outside India and take their approval. So generally these are called veto items, affirmative vote items. So sometimes what happens is, even though you have taken 20% of your 20% of the shareholding from a person resident outside India, but still you give certain rights to them, saying that okay, whenever I diversify my business, I will take your approval. Whenever I increase the whenever I take capital infusion into the company, I will take your approval. Whenever I will hire or fire certain KMPs, I will take your approval. So the condition under FDI to determine whether this company is a foreign owned and controlled company, there are three conditions. As I said, one is shareholding more than 50%. If not, then whether the foreign person resident outside India has the power to control the board. If not, then the third, whether the foreign person resident outside India has the rights to regulate the management policies of the company. So if any of these three conditions are satisfied, then you are called as a foreign owned and controlled company. If you are not a foreign owned and controlled company and all the three conditions are negative, then you are an Indian owned and controlled company. Then the downstream investment norms doesn't apply to you. But the moment you are a foreign owned and controlled company, with respect to these three conditions, any one condition is satisfied, you become a foreign owned and controlled company. Then you also have to see whether the money which you have taken from the foreign investor or any money which has been basically accrued into the company is going into which vehicles. For example, if I am a company wherein 75% of the equity is held by a person resident outside India. Now I have floated a subsidiary wherein I am doing different business. So the different business also has to make the test of FDI. So this is called as an indirect foreign investment. Because I am a foreign owned and controlled company wherein these three conditions, one of the conditions out of this three bucket is satisfied, I also have to apply the FEMA regulations at the downstream level. So a company has investment from person outside India of 60%. Now that A company goes and invests into a B company. I have to see that B company is also compliant in terms of FEMA regulations. So when I see that, I have to see what is the business that company is doing, whether the business the B is doing is in sync with the automatic route or an approval route or a negative list. So I have to apply that test there. Then only I can do that business and I can put in money from A to B. Second, I have to see what kind of indirect foreign investment is there in the company. So there is a method to calculate indirect foreign investment, and then I have to basically comply FEMA regulations. So this is called a downstream investment regulations in terms of FEMA. So you have to make sure that if you are a foreign owned and controlled company, then make sure that wherever you are applying, wherever you are infusing money, that company is also compliant in terms of FEMA regulations. So this concept is called as downstream investment concept. Now, once you have determined whether you are an Indian owned or a foreign owned company, if you are an Indian owned company, then the FEMA test stops there. But if you are a foreign owned company, then at all levels, wherever you are infusing, you have to apply this test in terms of seeing what kind of percentage of indirect foreign investment you have in the downstream company, and then see whether the RBI regulations are compliant in that business or not. So this concept is called as downstream investment. So I understand it is a bit complicated. So I will be showing you certain pictures to basically digest this more. But as a concept, I think this is the concept. So as I said, if you are a foreign owned and controlled company, then if you are putting in any money into another Indian company, then you have to file certain forms with the DIPP. The form is called as DI form. You have to inform them that, okay, I am a foreign owned and controlled company and I am investing in this company, and there is a form which has been prescribed. You first apply whether that company is eligible to get FDI in terms of the FDI regulations. If they are eligible, then you invest. Post that, you inform DIPP in terms of how much investment you have made. There is a form DI which has to be filed within 30 days of that investment. And there are other conditions also which has to be seen when you are making any downstream investments. So just to give you a rationale here why government has come out with this kind of a structure. Earlier, the companies used to have a shell company. That shell company used to invest in restricted sectors. For example, now, as I said, real estate business is not, it is under the negative list. So people used to come out with the structures wherein they used to have a back-end entity which will have the foreign direct investment, and then that money used to go into restricted sectors. So that's how government came out with regulations wherein they said, as long as you are not a pure investment company. If you are a pure investment company and you are under FEMA, you have to go to Department of Industrial Policy and Promotions, Economic Affairs Wing, and take their approval. And if you are not a pure investment company, then you can get FDI, but make sure that this test is applied. Wherein if you are a foreign owned and controlled company, and if you are investing at a downstream level, make sure that those businesses also comply with the FDI guidelines. That was the concept through which the government started to basically make sure that the restricted sectors are not getting FDI through different structures by putting back-end company, taking FDI and taking that money into restricted business. So that was the whole concept wherein RBI tried to liberalize certain things, wherein they said, okay, if you're not a if you're pure investment company, then only come to me for approval. But if you're not a pure investment company, make sure that you comply with all those guidelines. You take money. If you're an Indian controlled company, I don't care where the money goes. But if you're a foreign owned controlled company, then make sure that at all levels you comply with the FEMA regulations. This is the rationale at which I think RBI and the government came out with the downstream investment regulations. So, if you, as you see in the presentation, this is the direct foreign investment, wherein a foreign company or a foreign individual invests into an Indian company. That is a direct investment. But if you see the other side, on the right side, there is a column. It talks about indirect foreign investment. So, indirect foreign investment, again, a foreign investor invests into Indian company, and then give me one second. They are having indirect foreign investment into the downstream company, because if they are owning more than 50% here, or as I said, there are other two conditions, if those are met, then you also have to go at the downstream level and see whether there is an indirect foreign investment. So these are the certain definitions. What is an Indian owned and foreign company, and then what is the definition of control. So when you say owned is very clear. How much percentage of foreign investment should be there into an Indian company to say that it's a foreign owned company? It is very clear. It should not be. If it is more than 50%, then it is a foreign owned company. But there is a concept of control also, I said. So control, if you see here, there are two things: power to appoint majority of directors in a company, or to control the management or policy decision, including by virtue of the shareholding or management rights or shareholders agreement or voting rights. So as I said, there could be certain veto items wherein their approvals would be required irrespective of what kind of shareholding they are having in the company. So this has to be seen. So once you have determined that it's a foreign owned and controlled company, then make sure that at all the downstream levels, the FDI and the RBI regulations are taken care of. So these are certain pictorial representations of showing you how to calculate the indirect foreign investment. See, so non-resident entity is holding 40% in the Indian company ICO1, and then ICO1 is holding 10% into ICO2. So what is the indirect foreign shareholding in ICO2? The indirect foreign shareholding in ICO2 is only 39%, which they are holding directly into ICO2, because the number is 40% at ICO1. If this would have been more than 50%, the number would have changed, because it's less than 50%, and assuming that they don't have rights to control or have rights to appoint majority of directors, the first level company is an Indian owned company, and hence at the downstream level you don't apply the test. So the total foreign direct investment at the ICO2 is only 39%, which is directly held by the non-resident entity. But assuming that this 40% would have been 60%, then the indirect shareholding would have been different, because you have direct shareholding, you also have indirect shareholding. In the rule 2, you can see that. So here it is 40. In the rule 2, it is 51. So because it is 51, you also have to basically add the indirect foreign investment into ICO2. So direct foreign investment ICO2 is 39%, which is directly from the non-resident entity, and then indirect is 10%, which is 51. Because it's a foreign owned and controlled company, so you have invested 10% to it. Total indirect foreign investment becomes 49%. So this is how you have to calculate. Now, for example, the indirect foreign investment is 49%, and the business which you are doing only allows you to do you to get 24% of foreign investment. Then that means what? You cannot put in money into this at the downstream investment level. If your business allows you to get 100%, or if your business allows you to get more than 49% under this example, then you are allowed to get it. So at each level, you have to apply the test and see what kind of FDI is allowed, and then see whether you are breaching the test. This is the concept of downstream investment in terms of FEMA. Again, I think this gives you the same example. So this is the concept of indirect foreign investment, and your downstream investments, wherein you have to basically apply and see whether you are in compliance with the RBI regulations. Sometimes what happens is people don't know these regulations and then they think, okay, the main entity which has got an FDI is putting in money at the downstream level or investing in some other company. Because it's a domestic money, they need not, they don't think that the RBI regulations will come into picture. But I think this has to be remembered. What kind of entity is yours, whether it's a foreign owned and controlled company, then you have to decide whether RBI regulations will apply or not in terms of your further investment into different Indian companies. So next topic is on the swap of shares. Again, prior to 2017, I think any swap of shares would have called for an FIPB approval, but now it is under automatic route. So just to give you an insight into what is swap of shares. Now let's take the examples of an Indian company, which, for example, has certain foreign investors. So if an Indian company has certain foreign investors and the foreign investors want to swap their shares with another Indian company. So that means what? There is a company which has certain foreign investors, and there is a B company which has certain resident investors, and the A company shareholders want to swap their shares with the shareholders of B company. So that means what? The non-resident shareholders will get replicated in the B company, and the B company shareholders will get replicated in the A company. So that is called, that could be one scenario. There could be a scenario wherein the Indian company wants to acquire a foreign company. So they will take the shares of a foreign company from their shareholders and then they will issue shares of the Indian company. That could be one example. So in the second example, what is happening is the foreign company shareholders are coming and sitting into the Indian company, and the Indian company is going and sitting into the foreign company. So there is a FDI. There is also outward remittance. So in this case also, these kind of structures are allowed, but only thing you have to see is one, you have to value the shares of both the companies and you have to arrive at a swap ratio. Then you have to see the company wherein swapping is happening and the FDI is getting recognized. For example, as I said, the Indian company is going to swap shares with the shareholders of a foreign company. So that means what? Foreign company shareholders will become shareholders of Indian company. Whether the business of Indian company is eligible to get an FDI, that has to be seen. If that is the case, that is allowed. And then you arrive at the swap ratio and then swap the shares, and then whatever reporting is required in terms of RBI regulations, that has to be done. Previously, swap of shares was under the FIPB approval route, but now it is not, and you can do it under automatic route subject to these conditions. Make sure that if there is an inward FDI coming in, then your business is allowed to get that kind of FDI. And if you are doing an outward swap, then make sure that the other regulations called ODI regulations, overseas direct investment regulations, are complied with, and then get a swap share swap ratio computed by a category 1 merchant banker, and then you can do a swap. So this is the concept of swap. These are the conditions, as I said. If it's a ODI, FDI, both the legs have to be complied. Then merchant banker certificate has to be taken. So the other important aspect which we have to understand is, maybe we will go back to the FDI regulations. Once you have taken the FDI, what are the forms which you have to file with RBI? So this slide gives you the flavor of what kind of compliances have to be done. One is, once you have taken the money, within 60 days you have to allot the shares. So there is a timeline of 60 days. Under the Companies Act also you have a timeline of 60 days. Under FEMA also you have a timeline of 60 days. Either you allot within 60 days, and if for any reason you don't want to allot shares, then you refund within 15 days of reaching the 60th day. So either you refund it before, or you can refund up to 75 days. But this has to be done. If you don't do it, then there are different consequences. So allot the shares within 60 days. File certain forms. If you are allotting shares, then you have to file FCGPR form. So earlier there was a physical filing. Then RBI came out with online filing. The filing used to happen on EB's portal, but now RBI has their own filing portal. The filing portal is called forms. So on forms, you have to file this FCGPR form. Before you file the FCGPR form, if you are getting the FDI first time, then you have to create a master form giving all the details. Once you have created the master form, then you get a login password. Basis that you file the FCGPR form with the authorized dealer. You have to select the authorized dealer. So authorized dealer is the banker who has basically taken the foreign currency and created into your account. They will review the FCGPR. If they are fine, then they will forward it to RBI. Then basis AD's banker's comment, RBI will approve the FCGPR. So this is the filing which you have to do when you are taking an FDI. But previously we discussed, if you are transferring shares from resident to non-resident, non-resident to resident, then the form is called as FCTRS form. So the FCTRS form has to be filed with the authorized dealer, wherein if you are buying shares from a non-resident, the resident has to do remittance. So when they are doing the remittance, that time itself the FCTRS documents will be taken by the bank. They will scrutinize the documents and then they will do the outward remittance. So there are form DI also we discussed. If it's a downstream investment, then you have to file form DI. If you are issuing options to foreign nationals, then there is a form called ESOP form that has to be filed. And as I previously said, the money has to come through normal banking channels. So if you are taking any kind of an FDI percentage from a person resident outside India, make sure that the money is coming through normal banking channels. There should not be any cash remittance, or there should not be any remittance through a exchange, currency exchange, guys. It has to come through normal banking channels. Allotment within 60 days, filing of FCGPR within 30 days. And if for any reason you have not allotted the shares, make sure that you are remitting them back the money within 15 days, which is 75th before the 75th day. Form DI again, as I said, has to be filed within 30 days from the day you have made the downstream investment. This is the process for filing of forms. Now, just to give you certain, maybe before that, I will discuss certain case studies in terms of FDI for different businesses. So let's take maybe retail as a case study. So retail, again, there could be 3-4 scenarios. One, there could be a multi-brand retail business. There could be a single brand retail business. There could be a retail business which is online e-commerce. There could be a marketplace model. Maybe I will give you some insight into those kind of business. For example, now Amazon runs an online platform. You all know that Amazon only is a marketplace model wherein the vendors are listed on the Amazon portal. Amazon only facilitates the sale. They don't basically hold any kind of an inventory. They just show the vendors, as customer I can pick what I want, and directly it is delivered through vendor, through my logistic partner. And as Amazon, I only get the maybe marketplace commission or whatever. So that kind of model, it's not a pure B2C. It's not a business to customer or a business to consumer model, wherein it is directly, it's a service which Amazon is providing. So this kind of business, again, it's a retail business wherein I am not holding any inventory, but I am still categorized as a retailer. 100% FDI is allowed, but there are certain conditions. So when I say condition now, if you see, Amazon influences a lot of discount. They say, okay, Diwali discount, this discount, that discount, and they're trying to disrupt the Indian market. That's why government wants to make sure that the mom and pop shop guys are not getting wiped off from the industry. That's why they say, okay, as Amazon, you are a marketplace. I will allow 100% FDI into your business, but don't influence any kind of a discount. So Amazon cannot influence any discount. It's vendor who will take the call whether they have to take discount on their product or not. So this is one condition. And then there are conditions on if you want to put some inventory, then you can have some inventory which should not be more than certain percentages. So that is again a condition. So this is called as a marketplace model. Now multi-brand retail. Multi-brand retail is nothing but a retail store. It could be a brick and mortar store, or it could be a online store. So when it's a brick and mortar store, again, it is highly regulated. Government has said that if you are a multi-brand retail, when I say multi-brand retail, it means if you are a kirana, if you are selling kirana, groceries, or any B2C business wherein you have stores, outlets on the ground, then I will not allow any FDI. But in 2010-11, they said, okay, we will allow, but they have put certain stringent conditions. With the condition says, okay, minimum FDI should be 100 million. 100 million means 700 crores. Then out of that, 30% of your total procurement, you have to basically procure from Indian market. then you have to build certain infrastructure. So technically, under that route, no what do you call foreign investors invested till date. They were what do you call structures which Walmart and other guys are exploring, but their conditions are very stringent. For all practical purposes, even though on paper multi-brand retail is allowed up to 51% under the government route, but still I think it is very difficult, and no investor has come under that route. Then there is a concept called single brand retail. Now single brand retail is nothing but stores like Reebok, Adidas, Apple, wherein they are international brands and they are known internationally. So one of the major conditions to qualify as a single brand is you should be an international brand and you should be a manufacturer. So if you are a manufacturer, manufacturing, and you are internationally known brand. So when I say internationally known brand, as I gave you the example, Reebok, Adidas, Nike, Apple, these guys are known world over. So those kind of guys can invest, they can set up their companies into India and then they can do the business. Those they can do it as a 100% owned foreign owned company. So those kind of businesses are allowed. If you are, again, there are two conditions there. 100%. If you want to put in 100%, then 30% procurement has to be done from India. If you want to do it up to 51%, there are no conditions. Then online businesses. So when I say online, I previously said that marketplace. But if you want to do pure B2C online, you can do. That is allowed in India. It can be done. So this is the retail, what do you call, segment of it. And previously we discussed whether real estate, if it's a purchase and sale of land, that is not allowed. Agriculture is not allowed. As I said, IT industries and other sectors, 99% of sectors are allowed in India. Only few have certain restrictions and few are not allowed. So this is the entire ambit of FDI. Now there are few issues which have come after lockdown. So government came out with a notification that any investment from China which shares land, they didn't specify China, but they say any country which shares land borders with India, if those countries want to invest into India, then our government approval has to be taken. So the questions raised for China, now China also shares land border with India, whether China can invest into India. The answer was yes, they can do it, but they will require government approval. So any investment coming from China today will require government approval. That is the law. But the question arose whether Hong Kong is part of China, Taiwan is part of China. So previously people were confused whether Hong Kong is part of China. But I think RBI has taken a view that in consultation with the government, that Hong Kong will form part of China because of some political roots which China has into Hong Kong. And they said even though if money is coming from Hong Kong, still it will be treated as part of China, and then you will require government approval. When it comes to Taiwan, I think Taiwan, RBI has not come out with any kind of a clarification, but looks like from my past experience discussing with certain authorized dealers, looks like Taiwan, RBI has taken a view along with government that Taiwan, as long as the investor who is coming from Taiwan doesn't have any route into China, they are allowed. They will not form part of this restriction. So Hong Kong, I think, completely restricted as long as RBI or government doesn't give any clarification. But Taiwan looks like they can come under the automatic route subject to the FDI regulations. So this is the update on what is happening on China, what is happening on Hong Kong and Taiwan. Then maybe the other problem which a lot of funds were facing is, now I have a fund in China, but all my LPs, limited partners, or all my shareholders of that funds are from USA. So indirectly, I have a setup in China, but my ownership lies in USA. Still, the government has taken a view that even though the ultimate beneficiary is sitting in some other country, but still, because the roots are in China and the entity is based out of China, still the government approval will be required, and it's a process. So I don't know. So I have not seen any company which has which has got approval in this what do you call, lockdown or till date, wherein they have applied to government and they have come through. And public demo, no companies, I don't know whether they have applied, but I have not seen any cases where the government has given any kind of an approval. So coming from China could be a potential risk in terms of derailing the transaction or delaying the transaction. So that is an update on the China stuff. Now coming to the LSF, so there is a concept under FEMA late submission fee. Prior to maybe 2 years back, any violation of foreign exchange norms called for a compounding of offense. So when I say compounding, what happens is, as I said, you have to file form FCGPR, FCTR, or some other form under FEMA. If you have not filed that form, then, or you have filed the form but you have not filed within the timeline, then you have to basically, earlier RBI used to take a view that, okay, no problem, they'll just give you a warning and leave it. But off late, maybe 3-4 years back, they started asking companies to file for compounding. So when I say compounding, you have to file for a compounding application saying that, okay, these are the violations which I have done. I have not filed certain forms on time. Please pardon me. And they will go through the application, they will levy some penalty, and they will regularize the offense. That process is called as a compounding of offense. Now RBI, maybe 1.5 years back, has come out with a mechanism wherein when you are filing any form, FCGPR, FCTRS, Form DI, or any other form, if they see that you have contravened and you have filed the form with a delay or some other small violation, what they will do is they will say, okay, you don't apply for a compounding, I will approve this form, this is the penalty. They will, on the approval of the FCGPR, before the approval of FCGPR form or any other form, they'll just say, okay, this is the late filing fee, you pay it, and I will regularize the offense without you compounding. So this is something which RBI has come out, wherein they'll levy a minimum penalty and they'll regularize the offense. So there is a chart basis which they calculate the late filing fee, and then once you pay it, then your offense is regularized. Earlier you have to specifically file a compounding application, but now the application is not required. RBI themselves will regularize on paying of the late submission fee. So this is the concept of LSF. Now there are a few points which maybe a lot of people may have questions on. Whatever I thought, which I have learned from my experience, I thought maybe I'll put it on the presentation and we will discuss one by one. So the first is whether forms portal allows submission of multiple forms at a time. Now, as I previously said, RBI has launched their own portal and they said all the filings have to be done on this portal. So one of the practical difficulties with all the companies are facing now is there could be a situation where I would have got multiple investments into the company from multiple investors, or I would have done multiple transactions. So the problem in this portal is I have to file the form within a specified timeline. So if I have taken 4 FDIs, I have to file 4 FCGPRs, or I have to file 4 FCTRs. Now the problem is I have to file all of them within a specified timeline. So I will file the first form. The system will not allow me to file the second form because the first form is pending. So the problem here is by the time your first form gets approved, you would have already bridged the timelines for second form, because the system has been designed in a way wherein you cannot file multiple forms. First you file the form number 1. Once the form number 1 is approved, then you file form 2, then file form 3, file 4, and it screws up the entire timelines which are required for the other forms. And then at the end of the day, RBI will come hard on us and say, okay, you pay the late filing fee. So this has been a problem which we have represented to RBI multiple times, but we have not got any solution, wherein we said, because the system doesn't allow us to file multiple forms, and we are trying to file on time, but because of the system we can't file, and then you are penalizing us. So this becomes a big challenge. So this has to be taken care when you are planning for getting an FDI, because RBI has been very strict in terms of levying any kind of levying LSFs, even though you tell them that your portal is not out, but still I don't know why they take it as if the company has to be penalized. So this is a problem which the regulator has to note and they have to come out with a solution. But as of now, it looks like there is no solution. We will take the second question maybe at the last. Third one, consequences if the money is not refunded, neither the shares have been allotted within 60 days. Now, as I previously said, if you have taken FDI, then please make sure that you allot shares within 60 days or refund the money within 75 days. If you have done neither you have allotted the shares, neither you have refunded the money, then the problem here is you have to basically, you have to take RBI's approval before you do. So if you have not allotted the shares within 16 days, neither you have refunded the money within 15 days, then you have to basically take RBI approval before you allot the shares or before you refund the money. So generally what happens is if there for any reason the company has not been able to comply with this regulation of allotment within 60 days or refund within 75 days, we go ahead and allot the shares after the set period, and then you compound the offence by filing the compounding application with the RBI. And there is a chart given wherein they say that okay, if you have allotted after 180th day, 260th day, 360th day, they says that they levy the penalty. So that can be seen if the number is low, wherein you will end up paying only 10, 20, 50,000 penalty, then maybe you can take call and allot the shares, and then you may not take RBI, and then offence compound the offence. When do the investing company allowed to record the transfer of share in its books? Now this is again a tricky question. What happens is now I am a resident, I have gone ahead and I have transferred my shares to a non-resident. The company is not involved because as a shareholder I can transfer my shares to whomsoever I want, subject to the articles of association. Now the problem here is RBI says as the company should only approve the share transfer. When I say approve the share transfer, generally under the Companies Act, SS4 is given, and then when there is a non-resident is and the board has to approve the transfer. So what RBI says is don't take this transfer on record until we certify the form FCTRS. So they will certify the form FCTRS only after the form is filed on our forms portal. They review, they approve. So once that is approved, then only the company should record the transfer. This is again a controversial subject because RBI is taking 6 months, 9 months to approve the form. Now as a buyer, I am not on the register of members of the company, and RBI says until I approve the FCTRS, you should not take on record. So this is again a controversial subject, but in terms of the law, the company should not take on record the shareholder until the form FCTRS approval letter has been given by RBI, and that has to be given to the company along with form SS4 and then only the board should transfer the shares. For an initial transfer allotment of shares taken on relator yet to be received. So here the question is basically, for example, if I am a non-resident, I have subscribed to the shares of the company has filed the FCGPR with the RBI, but RBI has not issued the taken on record letter, or it is pending with RBI, and I have to transfer my shares to a third party, to a resident in India, whether I can do it. The problem here is under the law doesn't restrict you to do the second leg of transaction, even though the first leg of transaction is not approved. But based on our experience, we have seen that if a non-resident wants to transfer shares to a resident, the resident will do an outward remittance. Now, when the resident is doing the outward remittance, the authorized dealer who is doing the outward remittance will ask you the FCGPR and taken on record letter, which has been filed by the company when the non-resident was allotted the shares. Until you give the taken on record letter, they will not do the outward remittance. So make sure that the FCGPR is taken on record immediately, and then the second leg of transaction can be done. But if the first leg of transaction is not approved by RBI, if you want to do the second leg of transaction, then there could be a problem. Whether the payment of LSF regularizes the offence under the FEMA. Yes, as I previously said, the moment you pay the late filing fee, late submission fee, then the offence is as good as compounded. What kind of right constitute control for FDI? So this is again coming from a downstream investment perspective, wherein I said if you are a foreign owned and controlled company or an Indian owned and controlled company, you have to see three conditions: whether you are a shareholder holding more than 50%, or you have right to appoint majority on the board of directors, or you have certain control on the management policies or management affirmative rights. Now the question here is, what kind of affirmative rights will constitute control? So just to give you an answer in a short manner, any rights which will entitle the person resident outside India to control the management policy. When I say management policy, approval of business plan, right? Then maybe infusion of capital. Infusion of capital can be given, that will not come under the ambit of controlling rights. Then maybe borrowing, increase in capex, increase in working capital. So anything which is basically controlling the company in terms of the operations. So if you're trying to give any rights which will control the operations of the company, then it will come under the control definition irrespective of what kind of shareholding they are holding in the company. So make sure that this is taken care irrespective of what kind of shareholding the foreign investor is holding. The next question was, do Taiwan and Hong Kong form part of China? So I think this we have discussed. The other question which we discussed was, if a non-resident Indian investor is investing under the non-repatriation route, whether the filings will be required, whether the pricing guidelines have to be adhered to. So as I previously said, it is as good as a resident is investing if a non-resident Indian is investing under the non-repatriation route. So whatever is applicable to a resident, wherein pricing guidelines don't apply, and then your FCGB or other filings are not required. So that was the other clarification I wanted to give. I think I have covered all of it. Just give me 1 sec. Yeah, so I'll just jump to the questions. Hello sir, NRI has invested, 1 minute. NRI has invested on non-repatriation basis. He proposes to give 50% of his shareholding to the legal heirs who are non-resident and NRI. Is the proposed transfer required to be reported to the authorities? Okay, so he proposes to give 50% of his shareholding to the legal heirs who are non-resident and NRI. Again, if it is a gifting of shares between NRI to NRI, no government intervention will be there and you will not basically report this to any authority. But if it is a gifting of shares between NRI to non-resident, so when I say non-resident, it is a person resident outside India. And when I say non-resident Indian, there is a definition and you have to go through. So I'm assuming that he proposed to give 50% of his shareholding to a legal heir who are non-resident and NRI. So NRI to NRI, no problem. NRI to NR, I think this will require a government approval, wherein I think you have to file an application with RBI, take their approval, and we can do it. How to take permission from government when investment from China, whether through manual or e-form. So as I previously said, there is a wing of DIPP, Department of Industrial Policy and Promotion. The wing is called DEA, Department of Economic Affairs. You have to file the forms. So there is a portal. I think on the DIPP portal you can file it. So I'm also not sure on that. Previously, when we used to do it on FIPP, there was a FIPP e-filing portal where you used to file it. But whether DIPP currently has a portal or not, I don't know. So you may check that. So there is a wing called Department of Economic Affairs. You can go into their website and you can see. If not, then you can file it manually, and then it is in North Block, New Delhi. You can file it and then make the application. Whether there are any restrictions for FDI investment in domestic venture capital funds under SEBI AIF regulations. No, I think AIF regulations are allowed to get the FDI, but the only thing which you have to see is now AIF can get the FDI under automatic route subject to which category they are getting, which category AIF it is, 1, 2, 3. So that has to be seen under the SEBI regulations. If they are allowed under the SEBI regulations to get the FDI, then it is completely allowed. But again, when the AIF is investing into different companies, you have to see the control definition again here. If the AIF is controlled by foreign residents or foreign entities, then again the downstream investment norms will apply here, and then you have to make sure that the indirect foreign investment criteria is applied and you see that everything is taken care in terms of FEMA. Can a company receive FDI if it does not if it does contract manufacturing of food products and sale through own portal as well as different portal under a brand name? If it does contract manufacturing, yeah, so see, as long as it's a manufacturing company, if it's a contract manufacturing or a manufacturer, doesn't matter, it will fall under the manufacturing definition of FDI. So as long as they are manufacturers, whether they do it through a brick and mortar store or they do it through online, doesn't matter. But make sure that they are only selling manufactured products. They should not do any kind of a trading where they purchase goods and then they sell it to the third party. So that has to be taken care. So as long as you qualify under the manufacturer's definition, and if you are a contract manufacturer, then you can do either online or through brick and mortar stores. any maximum period of investment through FDI in Indian companies. Any maximum period of investment. No, there is no period of investment, but the only thing you have to say is if you are holding equity, no period. But if you are holding compulsory convertible preference shares, under Companies Act, the compulsory convertible preference shares have to be converted within 20 years. So there is no exit period which has been defined for any sector. But I think if it's an instrument which is under the companies has to be converted within a specified period, it has to be converted. But there is no exit period which has been defined under FDI regulations, wherein you have to put an investment and take out that money. If I have rightly understood your question, there is no exit restriction which has been given under the FDI regulation. Whether FDI is permitted in listed segment? Yes, again, there are two ways wherein a listed company can get FDI or foreign investment. So when I say FDI, again, as a foreign investor, if I am investing in listed company on a stock exchange, then it doesn't come under the FDI regulations. It goes under the portfolio investment scheme, where the regulations are different. All the companies, there are no restrictions, but yes, there are restrictions on how much a person resident outside India can hold under the portfolio investment scheme in a listed segment. But if you are doing a preferential allotment, being a listed company, again, you are at par with any other company. You have to make sure that your business is eligible to get the FDI, and all the pricing guidelines and all other requirements are taken care of. Whether we receive FDI due to rate change, if excess money received in bank. When we receive FDI due to rate change, if excess money, so in case if you have received any FDI and due to currency fluctuation, if there is any excess which has basically company has got, then one, if it is a nominal amount, if it's 1,000, 2,000, 5,000, 10,000, 20, 30, 40,000, you can basically take letter from the foreign investors that they are waiving this money and they don't want this money, and then you can basically keep it with you. But if it is more than a number, substantial number, then you have to refund that money back to the foreign investors. So you have to basically take a call whether the amount is nominal or substantial. If it's nominal, take a letter from the foreign investor who has remitted the money. They will say that, okay, we are writing off this amount or we are forfeiting this amount and we don't have any claim on this amount. And then the company can basically recognize that as a revenue, and there's no requirement of refunding that money. But if the amount is substantial, then maybe still if the foreign investor wants to give a waiver, fine. But if not, then you can refund back the money. When we thinking to refund excess SC, bank charges and certification cost more than, so I think that's a practical point. It's better that you take a letter from the foreign investors who will say that, okay, I'm waiving my amount, excess amount, and then that should be good. Is FDI allowed in agri-focused multi-brand retail? Agriculture is completely prohibited. If it's not agriculture, if it's multi-brand, again, if you are doing B2B, it will come under cash and carry business. If you are doing B2C, then it will come under multi-brand retail. So I need to understand what exactly you want to do. But if it's a pure agriculture, then it is prohibited. NRI to NR transfer by way of gift. Shares held on non-repatriation basis. So this will require RBI's approval, because a non-resident Indian is transferring his shares to a non-resident. This situation is not covered under FEMA. So you have to take RBI's approval, then only you can do it. Can NRI have a put option on company or promoter? See, again, contractually, I think under the FDI regulation, there is a limit wherein the promoter can give any kind of a guarantee of exit to the foreign investor. So when I say when you say put option, that means what? You would have contractually agreed that in case if the investor is not able to get exit from the company, that time the promoter will buy the shares from the investors. So I think currently that is allowed, but there is a specific number. I think it's around 10%. You should not give more than 10% of IRR. So if it is within the 10% number, then it is allowed, and if it is going beyond, then it is not allowed. So there is a specific number. So as far as I remember, it is 10%, but you can check the FDI regulations. It is allowed, but if it is beyond that number, then it is not allowed. So put option, call option, contractual obligation by the promoter to buy back the shares of the investor has to be agreed in the contract, and that contract should not breach this threshold, which I told you. And if it is not breaching that threshold, then this is allowed. Could you specify which regulation provides that the investee company should not record the transfer of shares unless FDI is approved? See, sir, I am talking in terms of my practical experience. I'll give you 2-3 examples. Now, if you see the master circular of 2017, I think after 2017 or 18, RBI came out with master directions. Now, if you see the master circular, not the TRISPRO regulations. TRISPRO regulations are not talking about whether the company should record the transfer or the company should not record the transfer, but the master circulars, which were actual master circulars, which were previously there, it specifically used to say that company should not record the transfer until the FCTR is stamped by the AD. Now, based on my practical experience, I was of the view, what is recording of transfer? I was of the view that recording of transfer means I should not record the shareholder into my register of members, but I can approve the transfer. But I think in 2017, RBI amended the TRISPRO regulations. That time, it was again diluted. So in 2017, we have taken a view that okay, this requirement is no more there, and then we can record the transfer, even though the FCTR is not stamped. But the problem here is I have myself compounded certain offences wherein RBI has taken a view. Under the law, the new regulations which are non-debt instrument rules, it still says that you just file the FCTRs, but RBI has taken a view, which I don't know from which law they have taken a view. They have taken a view and have compounded offences, and they have levied penalties on some of our clients, wherein they said you should not transfer, and this is the central, this is the instructions which they have got it from the central team. So if you ask me specific law, I am with you. The law doesn't say it, but in terms of my practical experience and how the things are on the ground, they are very clear. Don't record, otherwise we'll penalize you, and they have penalized our clients to the extent of 10-15 lakhs. This is from my experience. So that's how I have been telling you. But if you ask me the law, then law is very clear. It doesn't say that. But RBI has taken that view, and they are trying to levy huge penalties on the companies. Any other questions? We'll wait for 2-3 minutes and then we'll wind up. Is FDI allowed in agri-focused multi-brand retail? I think I have taken this question. So I previously said if it's an agriculture, it is not allowed. Now I don't understand what is agri-focused multi-brand retail. If you can elaborate, then maybe I will be able to answer this. So maybe you can elaborate it, then we'll take it up. Can you please focus on round tripping of funds in India? Yeah, so round tripping again, see, I'll just take 2 minutes to explain what is round tripping. Round tripping is nothing but money going out of India and coming back into India. That is called as a round tripping. Now, if you see the overseas direct investment regulations, not the FDI regulations, I think 1 year back RBI said any Indian company which has established a subsidiary or a joint venture abroad, that joint venture company should not invest back any money back into India. So that means what? The money has gone out of India, and then again that money should not come back to India from an ODI perspective. So as long as you are not hit by this ODI regulations where you have sent, for example, you have sent money into a under the liberalized remittance scheme into a different company. That company wants to put in money into an Indian company, no problem. The money can go and the money can come back. But if you are going under the ODI route, when I say overseas direct investment route, then they have categorically said if you want to basically send the money outside India, send it. But that money should not come into India by that entity should not invest back into India without our approval. So you have to go to RBI and take approval. So this subject to that, I think still round tripping is a very sensitive subject in India, but still RBI has not given any kind of a specific norms. Only under the ODI regulation they said you take our approval, but for other liberalized remittance scheme or any other remittance which you are doing outside India for some other purpose, that money is coming back to India, they are not regulating it yet. Can a non-resident Indian invest in an Indian company which is investing in agriculture land? A non-resident investing, No, it cannot be done. So if you are investing in agriculture land and if you are doing any agriculture business, uh, so here again there are two things. Whether the company is in the business of purchasing land and selling land, if it's a real estate business of purchasing agriculture land and selling agriculture land, not allowed. If you are in the business of purchasing agriculture land and doing farming, not allowed. But if you are in the business of purchasing land, then converting into non-agriculture land, and then doing any kind of a construction of residential property, it is allowed. What's the FDI rule around warehousing and logistics sector in India? Now, warehousing, I think it's allowed. It's a service sector, so you basically take FDI and then you build warehouses, give it on rent, or you store the goods. It comes if you are giving on rent, then it comes under lease rental. That is again under the service sector. That is allowed. And logistics, again, it's a service that is also allowed 100%. Is FDI allowed in trading of agri-focused items, for example, purchase of food, veg from farmer or sale of pesticide insecticides to farmers? Again, you can purchase any kind of agri-focused items, no problem. But it depends upon whether you are doing a B2B sale or a B2C sale. If you are doing a B2B sale, you are purchasing from a business and selling it to a business, then it comes under cash and carry, wholesale trading. Wholesale trading completely allowed. But if you are wanting to set up stores and sell it to consumers directly, then it is not allowed. It comes under B2C. Can we set off export proceeds from payable of import from same related party? I think it is not pertaining to FDI, but I'll try to answer this. Can we set off export proceeds, okay, from payable of imports from same related parties? Now here, it's not related to FDI, but it relates to export and import of goods. Now for export, if you see the export regulation, it says that within a specified period, the proceeds have to be realized by India. And if it's an import, then you have to, within a specified period, you have to pay. I think under the automatic route, it is not allowed if you want to set off your exports against the imports. And if you have a logical reason, rational, you want to do it, you have to file an application with Reserve Bank of India and take their approval and do it. And if once you get the approval, then you can do it. I think we are done. Any other questions? We'll wait for 1-2 minutes and then we'll wind up. So again, FEMA is a very complicated subject in terms of FDI, ODI, export, import. So this is the first session which we are doing on FDI, but we will be continuing doing sessions on FEMA with respect to ODI investments, export, import, then maybe other regulations which are coming under the ambit of RBI. So the idea here is to basically give you basic knowledge and then understand what are the nitty-gritties in terms of FEMA, because it's a complicated subject. So we will continue to come with different series for different regulations. So this was one of the try in terms of FDI. So we will focus more on FEMA and then try to come out with different series. I think we are done. Thanks a lot everyone for attending. So we will keep on conducting these kind of sessions, and we will be sending invites whoever is interested in getting some insight into FEMA and other topics which we will be coming out with. We can basically educate a lot of people in the industry, and then I think we will try to add value to the people who want to get into different. It could be people who are in practice, it could be people who are in industry, but we'll try to basically come out with this kind of series. I think that's it. So we'll log off. Thanks a lot. There are a few more questions which we will take offline. We will send you a reply through email. But for now, we are logging off. Thank you.